All right, welcome everyone to today's webinar where we are excited to launch our new Smarter Legal Review. As many of you would know, Chris Hill is joining me today, and Chris has been working alongside me for quite a while now. Chris, I think we've both got grey hair now. We probably didn't when we first started, but I guess it's a partnership that we're formalising that we've probably had informal for a long period of time. So to you, Chris, thanks for joining me today.
No, thank you, Aaron.
So let's get stuck into what we're going to be exploring in today's session. And the first part that we'll spend some time on to help you understand is the role in terms of the legal review of documents and where it's naturally going to be important. We continue to see this growing influence of defective documents, and Chris is going to spend a bit of time talking through what he sees, obviously what we see, and then how that translates into the case law that, Chris, I guess you've also been a part of, but you see quite commonly and we'll discuss as well. And then most importantly, where we see the greatest risks for you in your business and therefore your clients. As I touched on, we'll spend a bit of time talking about the formalization of this relationship through the Smarter Legal Review process. And we'll then also spend a bit of time wrapping up today's session, going through and demonstrating to you the process, not only explaining, I guess, visually through some diagrams in our slides, but actually take you onto the platform and walk you through the way in which this fits into the audit forms and some of the new forms that we've added as well, and help to explain some of the pricing that sits there too. So when we, I guess, look to kick this off today, one of the first things we want to do here is we want to understand from you, by way of poll, to understand what, I'll just get this up and running, what percentage of your clients do you believe potentially have a legal issue within their SMSF documents? So the fact that there might be maybe a broken link in the chain. It could be that potentially a process around the procedure in changing a trustee might be wrong. We might have an issue around the validity of a binding death benefit nomination and so forth. And Chris, whilst we get people doing this, these are very common areas that you see that are quite problematic.
Yeah, and also deeds appointing new trustees.
Yep.
We often see issues around the valid or invalid appointment of a trustee, the incorrect naming of the trustee. We even see issues with LRBA documents where the trustee of the super fund is the trustee of the bare trust, and that's often a conveyancing error or issue.
Yep.
But there's quite a few issues that we come across, relatively minor, some a lot more serious, but obviously have significant implications down the track, which we'll talk a bit more about in a moment.
Yeah, absolutely. Well, I'll just stop that poll there. And it's quite interesting that we end up with a fairly dispersed result there. So we can see here that we have some that don't believe they've got any, and some that might have very few, through to some that reckons there are some significant problems. And I guess what today is all about is to help you identify where those problems might exist. And if they do exist, the steps that you can actually take to resolve those so that you don't end up like some of these cases that we continue to see, and Chris, naturally, that you discuss on an ongoing basis. So the impact here is crucial because it's the defects in the chain of documents that then create problems when we see the upgrades. And recently in our SMSF days, we spoke a lot about in the succession and estate planning piece that we do have clients that have been around since the early 2000s and even the 90s and so forth, where the level of attention might not have changed, but the scope and the understanding of the way the rules work and the views that have been expressed by the courts really mean that, it is probably more likely with some of our older clients that we might have these issues than potentially not. And Chris, is that something that you see where, it's not only the function there, that the validity of the decisions create these potential problems that, historically we may not have really even worried about. But when we get to the cases that we're seeing in today's terms, these absolutely then come home to roost.
Yeah, and I think I guess the mission today is to sort of help advisors see the importance of the process or the service to avoid being a case, and to avoid, having to go to court to get a deed validated. And these cases usually arise where someone's challenging typically a death benefit nomination, and, based on the invalidity of the chain of documents. And basically, we don't want to see advisors being dragged into court to have their files overturned, or reviewed or to go through the cost or the risk of being a party to litigation.
Yeah, and the Narrowman one here is obviously quite interesting. We've seen a number of these, and probably becoming more and more relevant because of the fact that we need the court to determine the approach as to whether a trustee actually has the power to make a decision, whether then maybe a nomination is valid or not, because of the fact that there is, gaps in the chain that have occurred historically.
Yeah. And as you can see there, that the courts take, and Narrowman's a really good case example. It's a Queensland decision, of course, but it's a really good example of the black letter approach that the courts take. They will go through, if there's a chain of deed upgrades, they'll go through each chain, look at whether the power was validly exercised, the conditions of the power was followed in the upgrade, to see if that chain is intact. And so that's what we're trying to address here, rather than waiting to go to court and to try and validate a chain that's been broken.
Yeah, absolutely. So, Chris, I guess let's have a bit of a discussion here about some of the ones that we've seen in recent times. And the Victorian Supreme Court of Alicehill here is one of those where we saw the trustee ultimately go to the Supreme Court to have a decision made around, whether they were appropriately appointed or not.
Yeah, and Alicehill is a good case because it's a recent case, 2023, and it involved a super fund, an SMSF. So it's a really good case that gives us a lot of insight into the approach that the court will take, where in this case they couldn't find the original trust deed. And of course, what happens is that the courts are looking to decide whether the doctrines of rectification or the presumption of regularity is followed, and both of these doctrines are, and certainly the presumption of regularity is a rebuttable presumption, so it won't apply if there's a contrary evidence or if there's fraud. But the cases give us some real insight as to what we can do to cure defects in the chain. The Vanto Mantavati case, which went on appeal last year, is also helpful in looking at what secondary evidence is required if we're going to do a deed of adoption or deed of rectification. Prior to that, and prior to the introduction of the Evidence Act, you had to have clear and concise evidence, secondary evidence. Now those tests have been relaxed to tests based on the balance of probabilities. So we do have a lot more insight from these two cases on how to fix problems when it comes to a break in the chain or defects in documents, and how we go about that process.
Yeah, so interesting now, as you've said, we now have situations where, and case law where maybe the original deed couldn't be found, but there has been subsequent ones, and therefore the court has tried to make a determination based upon the information that they have in front of them. But yet we've also had situations like with Narrowman where the original one was done and there might have been a missing one in the middle, and then potentially we're having to look at the connection of sort of fixing up between 3 and 4 or whatever it is to ensure that deed number 5 or 6 is then absolutely relevant. So the longer that we go on, the more information that we've got, which is great, but it also then highlights some of the gaps that we then need to fix, because again, we don't want to necessarily end up in the situations where we're training people around the circumstances of these particular cases.
Yeah, and I think the good thing and the lessons from these cases is that courts have shown an eagerness to plug the gap, which has given us the confidence to know, okay, let's plug the gap at this end. So this is why this service is very important for advisors. We know that we can plug the gap in a defective chain of documents without you having to go to court and to get orders of the court to affirm, as what we saw with the LSL case, binding death benefit nomination and the change of trustee. So really what we're trying to do is avoid litigation or invoking the court's supervisory jurisdiction to approve what is to rectify what is a defective chain of documents. We can actually rectify that now with documents that are consistent with these cases, that will be compliant and give advisors obviously peace of mind.
Yeah, which is one of the reasons why we built the lost pension deed, if you recall, back in sort of 2018 when the or 29, whenever the Naruman case was, because it was the first time that we actually got some evidence that sat behind us in a court of law that looked at the fact that we didn't have any pension documents there, and there was a question of fact as to whether the pension was reversionary or not. Yeah. And the court looked at a whole range of circumstances that underpin the fact that they were confident that there was a pension actually on foot. So it's that sort of evidence that we naturally look to, not only in our Smarter SMSF deed in making changes. I know, Chris, you and I made some fairly substantial changes at 1 July 2023 in respect to binding death benefit nominations, again, off some recent case law. But it's these sort of things that we spend time on regularly to make sure that the powers to do things under the deed enable us to do it based upon where the courts are actually positioned today. Yeah,
the deed is an enabling document, so the courts look at the deed as being the rule book for all the processes and all the powers and functions of the fund.
Yeah, absolutely. So let's, I guess, move on and think about how these defects arise. And I think, Chris, you made the comment in putting these slides together that they can arise fairly innocently and also fairly easily. But the outcome of that sort of innocent mistake or omission or whatever can then have a profound impact on the way in which that fund can continue to operate. So I think if I can get you to maybe just touch on a couple of these areas, and then we'll go in and have a bit more of a discussion about how we've designed these in our specific rectification document as well.
Yeah, so the common areas that we see, and I'm sure our listeners see, are things like incorrect spelling of names, more seriously, perhaps incorrect references to the wrong parties. The client might have a number of companies and have put the wrong trustee in, not dating the documents correctly, or in fact, not dating the documents at all, or in some cases, not even signing the document. So the deed exists, but it hasn't been signed. So these are examples of what we call typographical errors, the minor errors that can be easily rectified. But of course, if you don't rectify them, what you're doing is opening the door for opportunity down the track where if there's a decision, say like a death benefit nomination that's been invalidated or sought to be invalidated, then all these issues come to the surface. And I'm involved in a case in the Supreme Court at the moment involving a deed that didn't have the approval of the employer sponsor back in 2008, and the discretions that are now being exercised are said to be invalid, and that's currently before the Supreme Court. Then we have what we call procedural errors. So you may be, in that example that I've just provided, you may require a deed to be upgraded with the consent of a guardian or an employer sponsor, which hasn't been obtained. And there's a lot of deeds that permit or require deeds to be upgraded via trustee resolution, and that hasn't been done. Some deeds give you the option to vary the deed by deed or by trustee variation or resolution. So these are sort of like omissions in the process that, as you say, are often innocently done and which cause problems down the track. And that's the issue that we're trying to address, is avoiding the issues down the track when somebody is disgruntled with either the outcome of a death benefit nomination or are looking to challenge. Right, so all these cases that we've seen, Mantovati, there was a case of Reed Thompson in 2015 involving an SMSF. I think they all start by somebody not being happy with a trustee decision, exercise of discretion, or in many cases, a death benefit nomination. So what we're trying to do is plug these little gaps, applying the principles from the recent cases to avoid advisors being dragged into that quagmire, and their clients, of course, down the track.
Yeah, and I think, Chris, here, the other thing to note is, and we see it a fair bit, where you've got a employer sponsor, participating employer, whatever, because of these older legacy deeds that sit around. And then there's been something done where the approval's only been done by, say, the trustees and maybe the members, and that principal employer has been forgotten about as part of that process. To fix that issue, you have to obtain the acceptance, in essence, of that participating principal employer, whatever you want to call it. But then there's nothing that prevents or precludes them from being removed as part of that process as well. So as long as that party to the deed, once that has been remedied, then no longer wants to be involved because it's a pure SMSF in its own right, those sort of things can be remedied at the same time as well.
Yeah, so when we're looking, as we'll touch on in a moment, we go through this process, we're looking for issues that obviously are presented to us, and maybe issues that we might see that we can flag with our advisor community, and that would be one of those if that is obvious from the material provided.
Yeah, and then the other one obviously is in respect to binding death benefit nominations, and this is obviously the big area that we've seen within the SMSF space, going back to Katz and Grossman, and then more recently, of course, our Hill and Zuda decision was emphatic ultimately in terms of the fact that 617A does not apply to SMSFs. We must go specifically to the terms of the deed, not only in terms of the construct, but the actual process to ensure the validity of that as well. And Chris, this is where, and I think the case that you were talking about before with the Supreme Court certainly is all about the procedure, and therefore the fact that if it's not done right, you end up with a level of discretion that the trustee may have, which then means we could have a period of disgruntlement and therefore action taken because of the fact that we haven't seen absolute procedure in this area.
Yeah, and what we're seeing, because of the build-up in SMSF assets, and the way that people are seeking to challenge the nominations, we're going to continue to see, particularly with an ageing population, more and more cases around disgruntled beneficiaries, particularly when it comes to an SMSF, or if there's an exercise of a discretion, disgruntled beneficiary, and they will seek to look through the whole chain of documents and the processes that have been applied to see if there's a defect. The irony with Hill and Zuda, of course, is that whilst it's clear that 617A doesn't apply to SMSFs, a lot of deeds that you and I see out there actually import it back in.
Yes, correct.
So they are then lapsing nominations, and this comes to the last point here, that is that often advisors will upgrade their deed, have done a nomination under a previous deed, and maybe upgraded to the Smarter SMSF deed, which is I think one of the best deeds on the market, and of course the nomination does not comply.
Yeah,
it has a different form. So advisors who are changing between document providers should upgrade or review the nominations, and that's part of the service that we're providing here as well, because as you can see from those cases of Munro and Donovan, it's very much about form. It's very much about whether the process has been followed, whether a trustee consent is required to a nomination, depending on the terms of the deed. It all comes back to the deed. And it's been well said, read the deed, read the deed.
Yeah, absolutely.
Yeah,
so the other thing, Chris, I think is, so we've spoken a lot about the risk in respect to the client and the ensuring the payment of the benefit, or the construct of the document ensures that what they want to have happen can happen. But the other thing then is around risk management for us as practitioners. Yeah. So And these are quite common questions we get. We have discussions with people regularly that look to our document service, and they say, well, who's behind the documents, and how do we ensure that we're managing risk in our business with this? So I'm really interested in your views around risk management for practitioners, and the way in which we've built this service and why we've built it that particular way.
Yeah, I mean, risk management happens obviously on a multiple levels when you're dealing with your clients. But as far as this service is concerned, what we're trying to do is give advisors a level of comfort that through an external review process, through my firm, reviewing documents, that they have a level of comfort that the deed upgrade or the documents that are generated on the Smarter SMSF platform won't be invalidated because of a prior document or series of documents. And I think that's important because not only for clients, but also for advisors. Yep. I mean, we had a case of Hill and Van Earp, which goes back to the 80s or maybe earlier, involving lawyers who are liable for disappointed beneficiaries. It's not going to be long before an advisor will be sued by a disappointed beneficiary because of a defective chain of documents or defective death benefit nomination. It's really a matter of time. So we see this as in the first level, a risk management strategy for advisors and obviously their clients. I mean, this is about protecting the clients and their affairs from being challenged, and the advisor's part of that, as well as the clients very much part of that concern. So we've navigated this, as we'll see in a moment, through scoping of the different levels of review, and we'll talk to that in a moment, and providing a certificate of legal compliance or certificate of legal review that will give something that you can put on your file, and you'll have a level of comfort that the documents, particularly those that precede the Smarter SMS documents, are not going to invalidate that document. And I think and end up in court, even at the very least, if it's not about being sued, it's about avoiding an application to the court for some sort of judicial ruling about a chain of documents, like we saw in the Ellisile case, that it is compliant, because in Ellisile there was a number of issues: lost original deed, trustee resolution. So they went to the court for directions. And so this is about saving you or your clients going through that process by plugging the gaps now, rather than avoiding or having to apply to the court to plug that gap, and with all the attendant costs and stress about it.
Yeah, and I think from that point of view, the communication, and people will see this shortly as we start to sort of unpack this, is the fact that the work is in essence being conducted by you. The legal sign-off is being provided by Hill Legal as the practicing solicitors here, and the level of work that is required is then scoped based upon the complexities ultimately that exists within the file that is looking to be reviewed. And one of the things that become very apparent very quickly is when we speak to prospective people that are looking at deed upgrades and that sort of thing, the common question is well, do you provide the legal sign-off certificate? Well, this provides that opportunity to do so. But very quickly, we've kind of had a bit of a soft launch of this over the past sort of 4 or 5 weeks. 80% of the work that's actually coming in is more like, we've got ourselves a problem, how do we actually fix this? And that's why we've provided, in essence, a couple of different solutions as part of this Smarter Legal Review to go, look, if you're looking for that certainty around the fact that we want the deed upgrade, but we want the comfort of that fact that Hill Legal and Chris and his team have gone through and ticked that off from a compliance perspective, we can cover that, but also we can remedy situations and give you that ongoing certainty, the fact that where there has been a break in the chain or a procedural issue or whatever, we can overcome that and allow for the fund to continue to operate with any major concerns looking into the future.
Yeah, and I think there's 3 scenarios, and that sort of became evident from the poll that we just did earlier.
Yeah.
One is that advisors will know, there are definitely problems in their files, and it's like, well, how do we deal with it? And it's sort of like in the too hard basket. And so, advisors tend to bury their head in the sand because it's a difficult problem.
Yep.
Then there's the second category, which is, there may be some issues. So there's some concerns about certain transactions, but you're not sure, right? In the first category, there's a problem. The second category, you have some concerns because you've inherited a bunch of documents, or you've inherited a client with a whole history of fund upgrades, and you think, well, I haven't looked at it, but I'm not sure. Then there's the third category is the unknown unknowns, like what you don't know. How do you know if there's an issue until it's looked at? You haven't looked at it. It hasn't had a legal review. So I guess part of this process is giving comfort through all those three the scenarios, is dealing with the known problems and fixing them, dealing with the possible problems, and then the third category, if advisors want that level of comfort, is going through their documents and getting them reviewed, regardless, depending just for that level of comfort, because they don't know what they don't know until a problem arises. And we're in a more litigious society, so obviously those concerns tend to come to the forefront.
Yeah, so there's a good question here. Deb's asked, in general, there appears to be little or no education or warning to trustees around pitfalls. And in general, if you're advising on old deeds or not complete deeds, the advisor is meeting resistance. The ATO and ASIC do not appear proactive in educating, but reactive in punishing. So, and I think it's a very, very valid statement there, because, deeds can be very specific, ultimately, and so therefore the ATO as regulator or ASIC as regulator really aren't going to be talking to specifics, because they can't. There is no universal deed. There's a replaceable set of rules under the Corporations Act, but there are elements within a deed that will be specific to a particular client. So it is therefore incumbent upon us as practitioners to be addressing these areas of risk for our clients and trying to understand what succession looks like. And part of this falls into the retirement income covenant in some respects that the government's sort of focusing on at the moment, that SMSFs aren't a part of, but trying to get clients to understand the fact that SMSFs are unique, because if you're in an APRA fund and the member loses capacity, it has no impact on the trustee structure. But in an SMSF, if that member loses capacity, it potentially blows up the entire structure of that SMSF without having in place the right building blocks. And then that comes back to, well, what documents do we need to have in play that allow for those building blocks to seamlessly continue for the trusteeship of the fund to occur? So we're never going to get something specifically come out of the regulators on this issue, other than the fact that we do need to contemplate these as part of broader exit considerations and broader succession considerations. So, Chris, I don't know if there's anything you wanted to sort of touch on there before we move on.
No, you're right. It doesn't come within the purview of the regulators, but it ends up in the purview of the courts.
Yes.
So that's why these issues tend to not get noticed, because they end up in a private piece of litigation. And it's strange that we saw 2 cases last year on the same issue. So we're going to see more, I think.
Yeah, absolutely. All right. Well, let's keep sort of pushing on here and talk a little bit about the relationship. And I guess, as we've mentioned, we've now partnered with Hill Legal here to be our service provider in respect to our Smarter Legal Review. And most importantly, Chris and I guess, very actively started working together when we rewrote the Smarter SMSF deed, or well, Ian Glenister's deed at the time. Yes, so Ed, myself, and Chris spent a lot of time obviously going through the comprehensive changes that we saw in the 2017 reforms. But I mean, the relationship goes beyond that. And obviously, Chris, you've been working significantly in the SMSF space and estate planning space for some period of time as well. And I guess the final thing from my point of view is, whenever we're looking at documents that are being added to the platform, where we're making amendments to the deed, any of those, all of what we do in essence goes past Chris's desk, where it has a legal connotation in essence linked to it. The fact that we want that certainty. We're experts at SMSF. We know absolutely what we're doing, but we want that additional level of review. Not only do we sort of send this stuff to many of our members and get their feedback on particular things, but that final belt and braces ultimately ends up in your hands, Chris, as well, where we debate and discuss stuff quite openly. And I think that, change to our Rule 11 around death benefit nominations was is a really good example of what we did last year.
Yeah. And look, the bottom line is that we want to keep our advisors out of court and their clients out of court. And we are seeing a growing number of cases. We saw the recent case involving a death benefit nomination that was made on the day of death, I think it was.
Yes.
Being supported.
Yeah, Van Camp, I think it was, from memory.
Van Camp case. And we're just going to continue to see this coupled with a build-up in SMSF assets and an aging population. It's a cocktail for potentially a lot of litigation. And so this process is about keeping you and your clients out of court and having complying funds, on different levels, based on education, which Aaron and his team are providing, based on quality SMSF documents, which Smarter provide, and of course, based on that, review of any prior documents. Yep. So that's the best way we see risk management for advisors in this space, is those three features that I've just mentioned.
Yeah, and that comes to this point exactly, Chris, is that the approach here is all about giving that peace of mind. So if people actually want that legal review to occur as part of that deed upgrade process, we've got that ability to then choose that. And then naturally the level of scope, which we'll talk about shortly, allows for that to occur. The fact that we're seeing more and more, probably more than we'd initially thought, in fixing the chain. So the defects, the fact that we need some sort of rectification or ratification or confirmation, those sort of things will continue to present as well. And, and I guess the final thing here is there is a solicitor that in essence will look over it. So it's that comment that you said before, Chris, as well, where sometimes you don't know what you don't know until you look at it. So the fact that there is a peer review that goes over the top of this, and where there is a situation where the scope of what might have initially been thought is not actually right, well, it'll be rescoped. And if it could be as extreme as saying, well, this defect, we can't actually fix this. So therefore it might go to the point where, at an extreme, you might go, well, look, we're better potentially just starting this whole process again. But there's a process here to be able to help work through with you on the remedies, on the cures that need to be done. Or if it can't be cured, then potential solutions that we can put in place as well.
Yeah, and look, we're looking at these documents in terms from a different pair of eyes, obviously, not as the advisor would see them. We're looking at them from a lawyer's perspective, and how would this stack up in court, or how could this involve some form of compliance issue? Whether we're typically talking about a court-related issue, but it could be an issue with a regulator, but most likely a court-related issue. And how do we solve that from our perspective?
Yep, absolutely. Well, let's get stuck into actually how this works. And what we'll do here is I'm going to sort of explain to you a little bit about the ordering process, and then we'll actually jump online and show you what we built into the forms as well. So we're going to look at this in two parts. So this is where we have a number of our documents that are available to order via the Smarter SMSF website. And the three that we've initially released here are around our deed upgrades, our change to trustee, and our binding death benefit nominations. Okay, so when you order on the platform, you will be able to choose whether either A, you are requesting legal review, or if you go to the bottom of the screen in the red, it allows you still to have that straight through process. If you don't want the legal review, you would simply request that you're not, and then it will review and submit. And if you need to pay for that order, if you don't have a subscription, you'll be able to do that as part of the process as well. But if you do want to request legal review, we then have some different options here for you that you need to determined. And we'll come to the scoping of these shortly, but in essence, we have 3 levels of review. One is our scope review, which is fairly straightforward in terms of the fact that we might not have multiple amendments and stuff that have occurred. We have our comprehensive review, which, as it indicates, is a lot more that needs to be done. And we have our bespoke review. And the bespoke review recognises that we are kind of outside of the 9 dots of the of what would be a fairly straightforward process in order to, in essence, get that update to occur or a change and so forth. And it's the bespoke review that also recognises that we may have a problem and therefore we may need to go through some sort of rectification process. Now, within the form, we expect you to then upload all of the documents to assist as part of that process. Okay, so there is a bulk upload ability there. There is some limitation on terms of file sizes. So if you can't, then we have put some tooltips in there. You can simply just upload that via a certificate. And we also ask you to provide some additional information that might not have got caught in the actual audit form itself. Okay, so there's just a free text box that allows you to give us some additional information that will help Chris and his team to be able to prepare that as well. Now, the other thing that you should note here is that we then, at this point in time, stop the ordering process. So in essence, you will review, submit, and pay. And again, I'll come back to the pricing points of that. But we will not generate the order, because in essence, what we're doing is we're now passing that information across to Hill Legal. So at this point in time, what I'm going to do is I'm going to jump over to our website here and just show you what we've got. So what I've done here is we've got our Smarter SMSF platform. I'm actually going into our new beta site here. This is open. This is in open beta now. And you can see here we've got our documents listed. We don't have all of our documents at this point in time. We're still adding them in. But you can see here we've got our rectification. And then down further, we've got our deed upgrade as well. So I'm going to click into the deed upgrade. One of the changes you can see here is all of our integrations now sit within the forms. You can go back and have a look at some of our Smarter SMSF updates to find out a little bit more about the changes that we've made with our new forms here as well in our Docs 2.0 platform. But what you can see here is we now have our Smarter Legal Review. So do you require legal review? Yes or no? What stage is this review at? So we're requesting, in this instance, legal review to be completed. We then have in here the different levels of legal review, and you can download the different documents and service levels. It has pricing in here as well. You can see the ability to upload and the file limitations, but it can upload multiple documents into that as well. You can then put in the fact that you can populate any additional information, as I said before. And then there is just the acknowledgements in respect to the fact that you acknowledge us to provide that information to Hill Legal in the first instance, because they're the ones that are preparing it. And you acknowledge that Smarter SMSF is not the one that is providing the legal sign-off. Rather, it is Hill Legal undertaking that work. So as you would ordinarily do in terms of a deed upgrade, you'll be able to populate that form manually through the actual integrations. And then you have the ability to go through and select that particular process. If you want to just do a straight order, you'd simply select no and then go through and actually complete that process. So we do have inside the back of this a range of conditions. So if you are a member, obviously the preparation of the document does not count towards your document order. But if you are choosing legal review and you are looking at legal review to be completed, and it's, say, a scope level 1 scope review, then you will be required to pay for that as part of the submission of the order. Okay, so that is the first thing to note. If it goes outside of scope, so i.e. we go through the order process and Chris and his team identify, and this is probably where I'll go back to our presentation, is if we get to the second page here, and you can see as part of this process, we've submitted the order, we are then passing that information across to Hill Legal. And what Hill Legal's going to be doing here is essentially confirming, based upon the information that's been provided, whether the scope of that work is correct or not. Okay, so you will get not only a confirmation from us to say it's been submitted and is being logged at Hill Legal to undertake that work. Within sort of 2 business days, you're going to hear from the Hill Legal team saying not only, yes, we've got it, but then confirming in essence that we have a level 1 scope review, as is the case here. Because Chris, what you may ordinarily see and identify is that there is maybe a little bit more to it than what that advisor had initially indicated.
Yeah, so what we will do is do a preliminary review of what's submitted, A, to identify whether it's in scope, and B, if there are other issues that need to be addressed or other information, which comes back to a point I was just about to make, and that is when you fill out that initial form, if you think there are some issues, tell us about it.
Yep.
Because the less that we interact through emails or other communications, the better for everybody. So give us everything you've got. If you have a concern or you think there is a concern and you would like us to focus on it, put that in the additional notes section. That's really important to me and my team to zero in on that. We will have our own checklists and processes that we'll go through as part of our review. But if you have a particular concern, tell us about it, and that may change the scope. It may not, but it will help us come back to you promptly to get this process finalised.
Yeah, absolutely. So I think from that point of view, there is a first step. So from submission, you will then receive some contact from Hill Legal. There's going to be no sort of interchange between Smarter SMSF. This is going to be done by Hill Legal, and that's very deliberately positioned from the purpose of who is providing that legal overview and oversight in respect to that. Once the scoping of that work has in essence been confirmed, so as is the case, then Hill Legal will prepare that legal sign-off that will in essence go with that document order. So you'll get that direct communication from Hill Legal there. What I should say is if there is a situation where it is re-scoped, Hill Legal will advise you of that rescoping and then provide you with in essence, a quote of what that additional fee may be. So if you paid Smarter SMSF $300 as part of that process, and then the fee jumps to $500, for example, Hill Legal will invoice you for the additional $200, given that you have already paid that $300 for what was the level 1 scoping in the first instance. So just to note that, you will then get the confirmation, that legal sign-off from Hill Legal, noting that upgrade is done correctly, if we focus on upgrade or the change of trustee or the binding nomination. And then what you can do is it will allow you, or once you've got that, you can then go back into the Smarter SMSF platform and in essence complete step 2. And that step 2 will in essence say, I now have my document, and therefore I acknowledge that the legal review has been completed, and we make you acknowledge that that step has occurred. And then once that step has occurred, we will then release or generate that document for you, and you will then combine those 2 documents together in terms of the provision of that for your client. Okay, so there is a couple of steps on the Smarter SMSF side. So one is the submission of that information originally. Hill Legal will then conduct the work that they need to, and naturally Hill Legal have the templates in essence of our current deeds and those sort of things, because Chris has been actively involved with these for some period of time. Once that has been provided, you then go back and complete the process, acknowledging that that legal review has been completed. Yeah, go, Chris.
Sorry, there's a question here from Monica, which is a really good question about, do we have a checklist or guideline for advisors to determine if a legal review would be necessary? The simple answer is yes, we will. We're going to put together sort of an FAQ document, which will give you some guidance about when we think a legal review is necessary. Now, in fairness, we're not going to. There'll be scenarios where it may not be necessary, but we'll provide a bit of a checklist as to what circumstances or facts emerge. Obviously, if you've got a client with a chain of documents, I think that's certainly a potential red flag that should require a review. I think that would be a starting position, and particularly if you've inherited those documents from another advisor, right, where you've not been involved in the upgrade, and so the previous advisor may not have the same detailed processes you've adopted. So that would be an example, but we'll put an FAQ together and we'll share it on the platform or our team will.
Absolutely. And then the other side of it is the rectification. So this is where we already know that there's an issue. So what we want to be able to do is to get that information across to Hill Legal so that we can start to unpack and then remedy what that potential issue is. So very similar process here. So as Chris and I touched on earlier, it is looking at things like typographical, missing information, and process-based errors. And again, through that submission process, we have what we call a simple rectification process that will, in essence, fix that price at $440, including GST. But you can see here the process is very similar. And as I go back to the Smarter SMSF platform, we do now have in here, under our documents, a deed of rectification. And we've got in here a Hill Legal logo. It's a bit bigger than I thought it was when I looked at it last night. But anyway, that's a different story. But our rectification form, in essence, goes through and captures that information that we need to rectify. So it may be an establishing deed. It may be a variation. Could be an LRBA, change of trustee. But what we're looking for is the error a typographical error? Is it a name, a date, an incorrect trustee listed, or an incorrect entity? So we can capture that information. So how many errors based upon the number of names? Is it a trustee, director, member? Is it missing information? So from a missing information, is it undated? Is it unsigned? If it's undated, what date should it have been done? Or is it unsigned? How many parties have or haven't signed it? Or in an other sense, we've naturally got the information that can be added in here, giving you some free text. And our process error. So is it missing a party, or is a party incorrectly been included? And again, an other that you can provide that particular explanation. And the process here again is that you can upload that information into here. And on our second page, what we are doing is we're capturing all of the information in respect to the fund. So the things that Chris will also need in respect to the, so we'll just say it's Smith Proprietary Limited there. We can put in any other information. We can upload our documents. And then on the next page, this is where something's gone wrong. That's good, isn't it? We can then go and utilize our integration to be able to capture the fund details. Okay, so we can go in, this is where we'll add in the API information to drag down from Class or BGL or Supermate to enable us to get that information in about the trustee, who the addresses are, who the members are, all that relevant information. If there are additional parties that we need to get as part of that particular process. So you can see in here on our new document platform, we now have added that deed of rectification. And then within our deed upgrades and that sort of thing, you will see that additional information as we touched on before in respect to those particular documents. So again, just making you aware that those tools are now available on our Smarter SMSF website. We're only adding them onto our beta documents platform. We are looking to decommission our old platform sort of by 30 June. So most of this will be moved onto our new platform. So we won't be adding to our existing one at this point in time. So, but anyone has access to it in its current form. So let's keep moving, given that I am conscious of time here. So you will get things like the confirmation request. So you'll see the order number, you'll see the name of the fund, the document that it's relevant, and then you'll get some information from us initially that confirms the fact that it has been logged and there will be some next steps to that. Hill Legal will then also, as part of their process, obviously be in communication with you as well. We then move to our pricing, and you can see here the different levels of review and the pricing and the time frame. So this is not the full list of information. We do have the scoping and all of that available on our smartersmsf.com/legal review page. So I'm just going to go over to here, and you can see this here under documents and Smarter Legal Review, and it comes down and talks to you about those different levels and all of the relevant materials in there. And you can also download the service table, and that service table gives you all of that scoping information, the common examples that we see, the prerequisites for us, and then naturally the exclusions in here as well. So you can go away and have a look at this in your own time. We will send some of this information through to you in the follow-up email too. But again, just making you aware of the way in which this operates, and where we do have fixed fees around certain things, they will be captured within the Smarter SMSF platform. If they are in essence POA, so price on application, then we will in essence be handing that over to Hill Legal to resolve with you, because obviously the level of work that is being undertaken, we don't necessarily know until that has been appropriately scoped. The other thing I just wanted to make people aware, because if you are going through and doing things like deed upgrades, we do naturally have our document packages that are available. So quite often we see people looking at specific projects within their organisation. So you go, well, we might go through and do a deed upgrade process. We've got 100 funds. So looking at our Create 100 package there certainly is something that may be an option. The other thing that we've also got on our new platform is a CSV import function. And that CSV import function not only helps bring in other data to do fund establishments and so forth, but will enable you to potentially do some bulk upgrades. So getting the data into the system to enable those bulk upgrades to actually occur. So in the new platform here, we've got our CSV import function. The idea being you can export that data out of your SMSF software or whatever CRM and so forth, pull that information in and then map that information. So if you want to do, say, 10 deed upgrades at a time or 20, we haven't sort of worked out what that maximum number is you'd be able to do at one point in time. But rather than having to rekey or each time using the integration, we will let you bulk upload that based upon what you've got in your CSV. And then it will create saved orders for each of those that then allow you to fast track that ordering process. So again, just a couple of features that we're adding into this as well to help you not only navigate appropriately to make sure that if you want that legal support, you can do so, but if you're doing projects within your organization, we've got this CSV functionality to assist, do that mapping, and most importantly, the mapping only needs to happen once, because you've then got the template that you can use to do your next 10 and your next 20 and so on and so forth. So a few features that we've got on our new docs platform that certainly work in this area for you as well. And Chris, I guess the final thing that we wanted to touch on today, of course, is the fact that in addition, and some people may have seen it on the screen before, is your other business, Inherit Australia. We do also now have the capacity to create enduring powers of attorney. So before I get you to maybe explain this a little bit more further, what you would have seen on the screen before is the fact that we have these enduring powers of attorney listed on the Smarter SMSF website. So again, if I go back to the Create New here, what you'll then see is the list of documents, and where we have these little icons on the side, it means that you can, in this instance, use the CSV import function, but in this instance, it will single sign you on over to the Inherit Australia website. Okay, so it will bring you across. You can then see here that you're signing up via Smarter SMSF. You can then go, well, I have an account already, for example, and then you're logging in. And then based upon the information that you have to log in, you'll basically log in and then be able to conduct the actual inherit order that you want to do. So I might just see if I can bring this one up. Then you can see here, it then gives you the capacity to go in and conduct the different powers of attorney. So, Chris, I might get you just to give a little bit of an explanation as I bring the slides back up here to explain what you've done in this sort of inherit space and how it can obviously benefit the members, not only with Smarter SMSF, but those that might be looking to put enduring powers of attorney in play.
Yeah, so we've built a suite of documents that advisors can order as a one-off. And unlike probably a number of other document providers in this space, we've built it so you can create customizable powers. So, for example, you can have a power to make or change a nomination or not to. And we've seen that from some recent case law around the ability of attorneys to make a power of attorney or not. Some clients don't want that to happen.
Yep.
So we create customizable powers, the ability to create multiple attorneys. We've made a digital signing feature for Victoria. We don't have digital signing in each other state as yet, but certainly Victoria, we can sign wills and powers of attorney digitally. We've got help guides, sign-on instructions, and we've also got the ability to create medical and enduring guardianship powers for 4 of the states. So that's something that's extra. But the Inherit platform is built for advisors to be able to have estate planning facilitation conversations with their clients. And a lot of the advisors that use the platform have SMSF businesses because they want to have conversations around death benefits and whether it should form part of the estate, particularly excess transfer balances. And that involves conversations around estate planning. So we've built the platform to help advisors have those conversations, and that can be a discussion on another occasion. But a feature of the platform is the one-off documents, and in particular, the last one there, Aaron, is the SMSF power of attorney.
Yeah,
we're pretty proud of because it fits only with the Smarter SMSF deed, and it essentially allows advisors to be able to not become a trustee, become a fund guardian, to have veto powers, so that clients who have attorneys that probably won't be that capable or functional, or maybe there's concerns about how they may abuse their office, those powers can be restricted through the SMSF power of attorney becoming a special rule of the fund. And there's probably a whole session around that at another occasion, but that's one of the features on the Inherit platform as well.
Yeah, so we'll naturally probably do a session on that in the near future. But I guess at this point, we've got that single sign-on to go across. There is some integration work that Chris and his team have done there. Arguably, we'd be looking potentially at being able to even utilise some of the integration information that we've got on our side and whether we can pass that across as well. We're at obviously the infancy of that, but wanted to naturally share with you today the fact that not only do we have the legal review, but behind that as well, if you've got some projects that you want to do with your clients around enduring powers of attorney as well, that has the ability to be facilitated through the Smarter SMSF platform as well. So I guess wrapping this up, Chris, hopefully what we've been able to demonstrate to you today is the launch of our Smarter Legal Review service. Is we recognise that there are ongoing challenges with clients, whether you're picking them up, whether you've had them for a long time. We know that the importance of mitigating risk is crucial. So the solution here is designed to provide you with peace of mind, not only peace of mind for you, but peace of mind for your clients as well. We've built this integrated solution. The fact that this information allows us to work seamlessly with Hill Legal to make sure we can get this done in a timely fashion and in a facilitated in a way that's cost effective as well. And as I've said, we'll continue to build out the technology stack that sits behind this to even fast track some of that process as well. We also acknowledge that there are different pricing points for the different things. We know that some clients just might have a fairly simple and straight through solution. We had an example only yesterday around a fairly simple rectification with just some wrong information about the trustee that can be very simply and quickly fixed through a simple rectification process. But the idea here is that the scoping of this can be done to deal with simple things, but also potentially something that is more complex. But most importantly, there's a solution for you to come to us to try and have that resolved for you and your client. And I think finally, Chris, here, it provides a real opportunity to go back and be quite proactive within your client base in addressing these issues and being at the forefront and front foot with your clients pertaining to a number of these SMSF documents as well.
Yeah, I think clients appreciate you thinking ahead of them rather than behind them, and this is a value add to your service to your clients.
Absolutely. Well, thank you everyone for joining us today. You can see here we have a number of events coming up, including our tax planning, SMSF tax planning, which is one of our largest ones for the year, includes access to our comprehensive checklist. We have our federal budget coming up shortly. And if you want to find out more about what we've been doing in the Smarter SMSF team, you can join us for our next webinar on the 23rd of April as well. Of course, these sort of sessions we do upload onto our YouTube channel. So if you want to go back and have a look at any of these other things, you can subscribe to our YouTube channel. We'll also send to you after today's session a copy of the slides, a survey, and a little bit more about the Smarter Legal Review Service. To you, Chris, thank you once again for being a part of today's session. Hopefully it's been hugely valuable for you all. Thanks once again, and look forward to seeing you at an upcoming event in the near future. Take care and bye for now.